Hello, I'm Richard of Quatrefoils Building Surveyors, and welcome to our CPD session this week for both in-house surveyors and anybody else who is interested. I thought we'd take the opportunity, as building surveyors who undertake a considerable amount of party wall award work, to look at a case that's been reported upon in the Faculty of Party Wall Surveyors newsletter. So, acknowledging and thanking them for putting this out. This case does have some interesting ramifications, and I'm going to read this. It's Amir, Siddique versus Kowaliw and Kowaliw, and in case I haven't pronounced that right, we're going to put it up at the bottom of the screen now if you want to look into it in some more detail. The case itself involved a fairly simple job of a loft conversion. So notices were served by the building owner's surveyor on the adjoining owner under section 2 of the Act. The adjoining owner dissented to the notices and appointed a surveyor to represent them. The building owner at this stage, mindful of the overall costs being undertaking fairly minor works, asked if he could agree in the use of the adjoining owner's surveyor as an agreed surveyor so that both parties could use the same surveyor, thus minimising the costs. It was at this stage that the adjoining owner said no, that they wanted to go through the two-surveyor process, forcing the building owner then to appoint another surveyor. An award was produced by the two surveyors in which they awarded the costs of the surveyors against the building owner, allowing the works to proceed. It was at this stage that the building owner then appealed the award, as they are allowed to do so within 14 days of being issued, and this appeal eventually found its way through to the Central London County Court on the 8th of March 2018, so quite a recent one from the date of making this video. Now, Judge Bailey, in looking at this, actually reversed the decision in the award and allowed the costs of the building owner's surveyor to be awarded against the adjoining owner. Now, his reasoning in here was that the building owner would have had to have paid for one surveyor in any respect. So he was happy that the building owner should pay for the adjoining owner's surveyor, as after all the adjoining owner had chosen that surveyor, and the judge felt that it was unreasonable that the adjoining owner, having picked a surveyor that would presumably represent his interest, that he would demand the building owner then to appoint somebody else. Now, this is quite contrary to the normal procedures as we have understood them in the past as surveyors, whereby the building owner would pay for both sides' surveyor. So this is something that we possibly need to be on the lookout in future cases, that if we do have a relatively small case where costs are an issue, you need to make the adjoining owner aware that if they do pick a surveyor and try, for whatever reason, to be awkward or whatever, to force the building owner to employ their own surveyor as well, that if they appeal it, they may end up getting the costs awarded against them. So be aware as surveyors, you've got to be mindful of costs, and you've got to advise the building owner and the adjoining owner fairly and equally on this. Clearly, in the situations where we've been involved in these in years past, we've been appointed by the building owners to serve notice, and in a way that by default means that we be appointed as the building owner's surveyor. In this particular case, the building owner's surveyor very reasonably stood down to allow the adjoining owner's surveyor to take the mantle, as it were, and gave them the opportunity to be the agreed surveyor. Anyway, thank you for joining us in this CPD session. There are many others, hopefully, for you to watch, and should you need any further advice, please don't hesitate to contact us through the website. Thank you again.